Johnson, you still under oath?
Yes, ma'am.
Thank you. Yes.
My lady, Leonard says this. Mr. Johnson, one final issue. Your cellular phone number was read out in court yesterday. Did you know about that?
My lady, yes, I'm aware of that.
How did you become aware of that?
During the morning session of the court proceedings, my phone started ringing incessantly. And the first call that I answered, the person informed me that, or asked whether I'm aware of the fact that my telephone number was read out in court. I informed the person that I'm not aware, and I also informed him that I have not testified, so please do not relate any of the details of the proceedings to me.
Yes, just try to be a little bit louder.
I beg your pardon.
Yes.
So what I said was, the person asked me whether I was aware that my number was read out in court. I then said to the person I was not aware that it was read out in court, as I'm awaiting witness in the witness rooms. And I also proceeded to ask them not to relate any details of the proceedings to me, as I have not testified yet. And then we ended the phone call. And thereafter I turned my phone off, and I received, when I turned it on, there were a large number of missed phone calls, and one voicemail message left from an overseas person.
Just a moment. We will not go through all the messages, but there's one particular message. Could you tell the court, you saved it on your phone, the message that you worked with Laing?
I have it saved on my phone.
What did it say?
Something to the tune of, I couldn't make out whether it was Mr. or Mrs. Berger. The person said, why are you lying in court about, we know Oscar didn't kill Reeva. It's not cool. Come on, man. Something of that nature. I can't remember exactly, but it was in a way intimidating.
And since then you haven't checked your phone for other messages?
Well, it keeps on ringing, my lady, so I keep it turned off. It's quite an inconvenience. I've owned that telephone number for close to 15 years. All my personal and business contacts know me by that number. So I feel my privacy has been compromised severely.
I have nothing further.
Thank you very much. Yes, Mr. Roux.
Thank you, my lady. Mr. Johnson, if I may ask you, please, and it might be difficult for you, but otherwise I have to move closer. I really have difficulty in hearing you. You're some distance away from me. So please, if it's possible, I know it's difficult for you in court, and you may concentrate on different things, but if you can speak up a little bit.
Sure, I'll try my best to speak louder.
Please. Where were you when your wife testified in court?
I was at the back in the witness rooms. I was at the back of the court building, the first floor in the witness rooms.
And you were basically available, should it have been requested of you, to give evidence directly after your wife?
Lady, that is correct.
You did not listen to a television broadcast offer evidence or to a radio broadcast offer evidence?
Milady, I avoided all media broadcasts. That includes radio, television, electronic media, printed media, Twitter, and avoided telephone conversations with my friends. I would respond with an SMS informing them that I will discuss, or I will call them back after I've testified. So I've done my utmost best to avoid any exposure to proceedings in court.
You also knew that because both you and your wife were coming to give evidence, that it would be advisable and correct not to discuss your evidence and her evidence with you.
That is correct, my lady.
So can I assume then that you two refrain from discussing what she would say to the court and what you would tell to the court?
Absolutely.
in her evidence, she made it clear that she did not read your statement. My impression was she did not want to read your statement deposed to by you to the police. And can I...
Just 1 minute, Mr. Roux. What is that disturbance? What is it? Pardon? Please stand up. What is it? Okay. You know, I just want to say this to you. Please, I hope this is the last time I reprimand somebody in court. I don't like it. Make sure that your telephones are off. Thank you. Take a seat.
Thank you, my lady. And can I assume that you would equally not have read her statement to sort of not compromise your evidence?
My lady, that is correct. I've never read or heard her statement that she made to Captain van Aert. In fact, I was not even present when it occurred. And I also did not read the notes, her personal notes that she made to herself as advised by Advocate Nikki Maritz.
So it seems then to me, to summarize this, when you realized from that time about a year ago that you were going to be a witness and your wife was going to be a witness, you deliberately refrained from discussing the matter. That's one, is that correct? Two, from exchanging notes on the matter.
Can I just, my lady, can I reply to the first question? We discussed the matter, but not each other's evidence, more just in support to each other. It was a traumatic experience.
Yeah, just the emotional side, but not the merit, not the factual content.
Absolutely.
Yes. You also deliberately did not read her statement, and she deliberately did not read your statement.
That is correct, my lady.
You also did not exchange any notes on it.
That is correct.
Yesterday you also sanitized, you blocked yourself out from any influence what the evidence might have been in court.
That is correct.
We saw that your wife, she concluded the testimony, she left court, and then we saw her coming back into court again when you entered the court to testify.
That is correct.
Now let's look at some of the things in your evidence. And first of all, if I may ask the state to make Exhibit N, that's for Nelly, that is my lady and learned assessors, that is this witness's statement. Available.
Thank you.
Whilst we're finding the statement, in the meantime, I just want you to identify that that is indeed the statement that you deposed to, where to Mr. van Aert.
Can I confirm this is my wife's statement?
No, not your
Lady?
wife. I want your statement. It's Exhibit N. Just make sure that that's indeed your statement, and that's the statement that you made to Captain van Aert, and it's your signature.
Yes, my lady, I
And my
confirm.
understanding is that Mr. van Aert was very professional. You told him your version. He took it down, as policemen must do. He read it back to you. You were satisfied. Then you signed it and you took the oath. You affirmed the correctness of the statement.
That is correct, my lady.
And you were satisfied that your statement reflected a true position of the events?
According to my observations that evening,
No.
I believe this is accurate.
Yes. And as your statement was made at a time that was relatively close to the events would have been sort of fresh in your memory. It was not a long time. It was a month after the incident.
That is correct, my lady.
Yes. Now, I want to ask you certain things about it, Mr. Johnson, if you would bear with me. I'm going to deal with a number of aspects that I will argue to the court that it's striking that you were yesterday in a position in your evidence of chief to testify about it. I'm going to start with the first one, and let me immediately preface it by saying to you the first point that I'm going to raise would seem to be really insignificant, and that is when you went to bed. And I know it doesn't matter really on the merits of the case whether you went to bed at 9 o'clock, 10 o'clock, 11 or 12 o'clock or 8 o'clock. But it will be used in conjunction with other points. So I'm sorry about the first point. But what was interesting about your evidence yesterday is this, that you say that in your evidence that you went to bed between 9 and 10. You remember that?
I do, that is correct.
Now, of course, how insignificant it might be. What was interesting, that in your statement, as you will see, you say that you went to bed approximately 9 o'clock. However, in your wife's evidence, she used exactly the same time, not approximately 9 o'clock, but that you went to bed between 9 and 10, the same as your evidence yesterday.
Must I respond, my lady?
Yes.
I don't find it's funny. It's our routine. We are highly routinely based people, and if you have to ask me what time I went to bed 2 weeks ago, I would confidently answer between 9 and 10. That's our, we go to bed, we finish up and retire between those hours.
Mr. Johnson, the point is maybe different. Whilst you would so confidently answer between 9 and 10, that was not your statement. But we'll get to the other points. This is a small one. Your statement was approximately 9 o'clock and not between 9 and 10. It is just a coincidence, perhaps, that your wife testified that it was between 9 and 10, and yesterday when you testified, yours were also then, contrary to your statement, between 9 and 10. That's all I put to you. But it's not because you've discussed it with your wife.
Not at all.
Good. Now, the second point is this. You can go through your statement, and I will not mislead the court, but in paragraph 5 of your statement, 4 and 5, you deal with making a call to the security and the wrong security and whatever, not too important. But what you don't deal with was what was the situation at that time with the woman screaming. You agree?
Milady, that is correct.
You don't deal with it in your statement. Now, will you accept it when I put it to you that likewise, and the statement is before court as Exhibit M, likewise, your wife deals with the telephone call to security and also in a statement does not deal with whether there was screaming at that time. Will you accept that?
I accept that, yes.
Yeah. Or whether she heard screaming or whether there was screaming, whatever, same as yours. Both of you in your statements did not deal with it. However, in cross-examination, I asked her about it. And she said words to the effect that at that time she was not focusing on concentrating on the screaming because of the telephone. You understand?
I do.
Of significance yesterday, without the state prompting you, no question from the state in that regard, you tendered evidence consistent with that of your wife that she had not dealt with in her affidavit to say, state and ask you about it. I didn't pay any attention to any sounds coming from the house or the direction. How is that? How is that your wife was cross-examined? It's not in your statement. It is not in her statement. She was then cross-examined about the screaming at the time of the telephone call. And she said that she was focusing on something else, meaning she didn't pay attention. You then, out of your own accord, without the state asking you, go there and say, without anyone asking you, I didn't pay attention to that. How's that?
It's quite simple. It's notes that I made to myself after the advice of Advocate Nikki Maritz. And I've obviously reviewed those notes to remind myself. That's a note that I made, that I did not pay attention or wasn't aware of any sounds that came from the direction of where the incident happened, because I was focusing on the telephone call.
Can we see the notes?
I don't have a printed copy available.
Can you tell someone where it is and go and fetch it whilst you're in court? That we can look at the notes.
I have no problem with that. I have a copy on my iPad, which is in the witness room back.
Well, so we can print it, and those notes were made before your statement.
That is correct, yes.
And you agree that you give that note to Captain van Aert?
I did not. I informed him about it, my lady, and he said I must keep it in a safe place.
And your first statement that you made to the two policemen that came, where is that? Did you keep a copy of that?
I did not receive a copy of that, my lady. It was I would term it as just a casual conversation relating...
Did you not make a written statement?
Not that first evening, my lady.
Not the first evening, sorry, you just referred to that statement in your evidence.
Yeah, so there were two visits. The one evening was by the two investigating officers, my lady. And then in the following week, Captain Mike van Aert contacted me, made an appointment, and that's when I made my first official statement.
Your iPad will of course show when you put the notes on your iPad. Did you put it on at that time, or was it more recent?
My lady, I have a copy. The notes were made on my personal laptop computer, and I've kept it there, a copy. Last night I converted the notes to a PDF format and transferred it to my iPad.
So we will be able to see when the first note was made.
My lady, I think it would be possible to derive that from the file history.
But we will get it during the adjournment. We'll get the notes, and surely you're satisfied to show it to us.
Absolutely.
And what caused you to make that note?
It was, my lady, it was on the advice of Advocate Nikki Maritz. He said that normally these cases take a very long time before they are heard before a court, and your memory will fade. So he advised us to make notes in as much detail as we can remember, to rely on to refresh your memory later on.
But it's a bit different, because this is not a note of what you observed. It's a note of what you did not observe. It's a negative. That's why I'm asking.
My lady, the note, the content of the note describes the entire experience. What I make explicit mention of the fact that I did not pay attention to the sounds from the direction of where the lady's screams were coming. It's one sentence and probably a 1.5 page document.
We'll look at the notes. That's not important.
Well.
Now let's go to the next point. In your statement, and I want you to read it out, paragraph 6. Just before the shots. I can help you. It says, ek het die vrou gehoor gil. You see that?
I do.
Now, in your wife's statement, she says the same thing in paragraph 6. Ek het die vrou gehoor gil, meaning I heard the woman screaming or yelling.
I accept that.
Yes. However, in your evidence, you then describe the screaming. You defined that. You said that it was more intense. You could hear the fear. You remember that? Would that be correct?
Are you referring to my testimony yesterday?
Yes.
Yes, my lady, I remember that.
Is that in your note?
I can't recall.
Yes. Now, what is significant? In your wife's evidence, not in a statement, she also defines or describes just the one word gil or the yell or the scream to say that it was more intense and she could hear the fear, exactly the same. And it is remarkable that it is not in her statement, not in your statement. She testified about it to describe, and you come and you testify about it in the same manner. Can you explain that?
It's, I would venture a guess that it's the way you verbally tell the story.
Yes.
There's a lot more emotion involved when you convey the experience,
Yes.
where the statement is more factual.
Well, let's go on. Let's go to screams. If you look at paragraph 6, I read to you, first die Afrikaans, ek het die vrou gehoor gil en toe 'n sarsie skote gehoor. To translate, I heard a woman screaming and then I heard a volley of shots. Are you satisfied with my translation?
I'm satisfied.
Is that what you meant to tell the person that took the statement from you?
That is correct, yes.
Yes. In your wife's statement, it starts the same. She heard the woman screaming and then 4 shots. You just had a volley of shots. She had 4. I heard the woman screaming and then the shots. So that's in her statement, that's in your statement. However, in her evidence, she said, and she used now explicit words, that she heard the screaming also during the shots. You have that?
Yes, I do.
You come to court yesterday and you testified now with explicit language that you don't have to infer from it that you heard the shots, the screams, also screams during the shots. Do you agree?
I agree. That is
Yes.
exactly what I heard.
Let's go to the first one. Next one. Let's go to your statement, paragraph 6. You say, and I first read the Afrikaans that you can find it. Die laaste gil was net na die laaste skoot. 1 tot 2 secondes, meaning the last screen was just after the last shot, plus minus 1 to 2 seconds. You have that?
I do.
Your wife's evidence, not evidence, statement. The woman gave the last screen about 2 seconds after the shots. You see that? But when your wife came to give evidence, she said the following. She said that the last screen, she said, I heard her voice fading away with the last screen. Significantly, when you gave evidence yesterday, as it was not stated in your statement and your wife's statement, but in her evidence, you said the following. The last screen, it faded moments after the shot. The fading. She spoke about the fading of the screen after the last shot, and you speak about the fading. How is that?
When we had to testify, my lady, or not testify, make the statement, I used the indication of seconds to indicate a very short duration. I chose different words. If I have to describe it verbally, that's how I would explain it. I think the 1 or 2 seconds perhaps came in response to a question from Captain van Aert, how long? I'm fairly certain that I would have given him a similar version, verbal explanation of moments after the last shot, the last screen faded away. And then I think he asked me how long were the moments, and to try and peg a time frame on it, I probably said 1 or 2 seconds, or it could be half a second.
Mr. Johnson, it's not about the time. It's about the exact same word. Not in your statements, only in her evidence. Fading. And then in your evidence, fading. That's what it's all about. Now, it may be a remarkable coincidence, but I'm dealing with 6 of them now in a row. You understand? I've taken the first one, the time, where it then became exactly a time. And so I went through it. I don't want to repeat it. I'm now with the one fading. Will you want to give an explanation again about the coincidence of using the same word that she used on a cross-examination that was not part of your statement?
Lady, I'm satisfied with my explanation.
Would it be part of your notes?
Lady, can Advocate Roop just clarify what you are referring to?
You know your notes that you have on your laptop?
I mean, what in the notes?
The fading.
We would have to go and look at the notes, my lady.
Of course. Well, let's go on, Mr. Johnson. Let's go to paragraph 6 still of your statement. In your statement, paragraph 6, when you describe the shots, you refer to it. I first give you the Afrikaans. You say, en toe 'n sarsie skote, then a volley of shots. We all know in Afrikaans and in English a volley exactly what it is. Now, your wife gave evidence to say after the first shot there was a small pause. Couldn't give the time, but there was a small pause. When you gave evidence yesterday, what did you say about the duration between the shots instead of a volley of shots? What did you say? Can you remember?
I recall, my lady, that I testified that there was a pause between the first shot and the shots that followed.
A small pause. between the first shot and the other shots. Exactly the same as your wife's evidence. Not in her statement, not in your statement. You agree?
I agree.
How is that? Is that a coincidence?
My lady, I don't think it's such a big coincidence. If two people stand 10 meters apart from each other, witnessing the same incident, that they would have such similar recollections of the event.
It is not that, Mr. Johnson. It is where it differs from your statement. It is not the same. It's not contained in your statement, and it was in her evidence, and then it is in your evidence, and then I start to understand, or maybe not understand, why you did not give evidence directly after your wife's evidence. You were available. What was in it? Why did you just not come and give evidence after her evidence?
My lady, is Mr. Roo referring to yesterday?
Yes.
I did give... No, I don't know.
Mrs. van der Merwe was called in between, so as to have that opening period.
My lady, I'm sure she wouldn't mind me volunteering this information. She was extremely nervous and kept on saying to us she cannot take another day of this. She wants to carry on with her life, and I think for that reason Advocate Nell obliged and gave her the opportunity to testify yesterday.
When did she tell you that? After her evidence?
Milady, no, that was during our period that we waited there. She said she was going to request that she could testify.
During what period?
Milady, it's during the period that we waited in the witness room. Asked me whether I was aware that my number was read out in court. I then said to the person I was not aware that it was read out in court, as I'm awaiting witness in the witness rooms. And I also proceeded to ask them not to relate any details of the proceedings to me, as I have not testified yet. And then we ended the phone call. And thereafter I turned my phone off, and I received, when I turned it on, there were a large number of missed phone calls, and one voicemail message left from an overseas person.
Just a moment. We will not go through all the messages, but there's one particular message. Could you tell the court, you saved it on your phone, the message that you were relaying?
I have it saved on my phone.
What did it say?
Something to the tune of, I couldn't make out whether it was Mr. or Mrs. Berger. The person said, "Why are you lost?" That includes radio, television, electronic media, printed media, Twitter, and avoided telephone conversations with my friends. I would respond with an SMS informing them that I will discuss, or I will call them back after I've testified. So I've done my utmost best to avoid any exposure to proceedings in court.
You also knew that because both you and your wife were coming to give evidence, that it would be advisable and correct not to discuss your evidence and her evidence with you.
That is correct, my lady.
So can I assume then that you two refrained from discussing what she would say to the court and what you would tell to the court?
Absolutely.
In her evidence, she made it clear.
I'm in court about, we know Oscar didn't kill Reeva. It's not cool. Come on, man. Something of that nature. I can't remember exactly, but it was in a way intimidating.
And since then you haven't checked your phone for other messages?
Well, it keeps on ringing, my lady, so I keep it turned off. It's quite an inconvenience. I've owned that telephone number for close to 15 years. All my personal and business contacts know me by that number. So I feel my privacy has been compromised severely.
I've nothing further.
Thank you very much. Yes, Mr. Roux.
Thank you, my lady. Mr. Johnson, if I may ask you, please, and it might be difficult for you, but otherwise I have to move closer. I really have difficulty in hearing you. You're some distance away from me. So please, if it's possible, I know it's difficult for you in court and you may concentrate on different things, but if you can speak up a little bit.
Sure, I'll try my best to speak louder.
Please. Where were you when your wife testified in court?
I was at the back in the witness rooms. I was at the back of the court building, the first floor in the witness rooms.
And you were basically available, should it have been requested of you, to give evidence directly after your wife?
Lady, that is correct.
You did not listen to a television broadcast offer evidence or to a radio broadcast offer evidence?
Milady, I avoided all media broadcasts.
Mr. Johnson, you still under oath?
Yes, madam.
Thank you. Yes.
Milady, Leonard says, Mr. Johnson, one final issue. Your cellular phone number was read out in court yesterday. Did you know about that?
Milady, yes, I'm aware of that.
How did you become aware of that?
During the morning session of the court proceedings, my phone started ringing incessantly, and the first call that I answered, the person informed me that, or asked whether I'm aware of the fact that my telephone number was read out in court. I informed the person that I'm not aware, and I also informed him that I have not testified, so please do not relate any of the details of the proceedings to me.
Yes, just try to be a little bit louder.
I beg your pardon.
Yes.
So what I said was, the person asked